have, and you can do this through this discovery, whatever, if you can get a hold of the guy's insurance company, whatever, the name of the carrier, maybe he's self-insured, maybe he has no insurance, but he's got to have a bond. He's got an oath of office. The oath of office is a contract that he has with you, with me, with everybody in here, that he will not violate us, and he will at all times defend the Constitution against anything that's going to violate us. How many times did they not do that? Every time. They're doing it constantly. So now what we do is, I think Randy also put together on his site tort letters. We file a tort letter to the insurance company. With the tort letter, it's basically structured like a complaint, a criminal complaint, to the insurance company stating the date, the time, the attorney or the judge or whatever. Judges have insurance too. Go to their bonding company and you say, I was harmed by such and such on such and such a day in violation of judicial conduct rules, attorney rules, procedure, the whole works, and constitutional violation against my rights, causing me damage and harm. Now, you have a complaint into them, and you can assess damages. If I run into your car on the way out of the parking lot, I can do a couple different things. You can turn it into the insurance company, or we can settle it offhand, okay? And I could pay you the $100 and you say, okay, goodbye, hit the road, no problem. Just give me a receipt that we're all squared away. Or if you turn it into your insurance company, then the insurance company will come after me. The insurance company will pay. They'll pay you, but then they'll come after me. And it's the same with the bond. That's what it is. It's just an insurance that these judges and lawyers have. So we need to file tort letters against their office and how they violated their oath of office against us.
Have they created any type of, I want to call it a hidden procedure, where the insurance companies might actually say, if you don't use this process, where the insurance companies might say, if you don't use this official complaint process first, you can't come to us. You see what I'm saying there? In other words, maybe they're so in bed with them that, I mean, how infrequently do
we have exhausted our administrative remedies?
Yeah, I'm sorry, you just described it perfectly for me. That in order for you to bring a tort against lawyer X, you have to use and exhaust this administrative remedy that's set up through the Bar Association or Judge XX, through the Commission on Judicial Conduct in the 4th Department, or...
I'm not sure.
That tort letter is basically a shot across their bow. It's a warning letter. It's give me a remedy to this or be sued. That's the idea behind a tort letter. So you can send a tort letter, but if you do the bar agreements, they have canons of law they're supposed to follow, professional rules of ethics. They are required to notify their insurance companies of it, and the insurance companies will contact the bar. Now, the bar is not going to give them any information, which leaves the insurance companies to assume the worst. They'll send you a letter back saying it doesn't rise to the level of whatever you're complaining about, and get a circular file, basically. And the insurance companies will presume the worst of what happened because the Bar Association will release it. So when they do that, that's what makes the insurance go up and up and up. And I don't care if you've been practicing law for 30 years. If you get 3 bar agreements against you, your firm's insurance goes up and you're out the door. They won't put up with it because it'll skyrocket.
Does that answer your question?
Yeah, it's the shot across the bow is a good thing.
What we need is more people to start filing grievances against these attorneys and judges. Yeah, the air conditioning feels good.
Wow.
You guys feel it? Wow, nice. Okay. Has everybody heard of the Confiscation Act of 1861? You have? Okay, would you tell us what it is?
The gold seizure.
Okay, in the Confiscation Act of 1861, one of the main things is that they are to leave us alone as we are non-combatants. We are peaceful inhabitants. They used the Confiscation Act to take away all the property of all of the combatants in the Civil War. They took their homes, they took their money, their bank accounts. Okay, that gave rise to, in 1863, the Leader Code. Article 1 through Article 157 is called the Rules of Engagement. Government officials, their rules, regulations, and guidelines, they were not to use or misuse that office in order to extort, pillage, plunder, abuse, misuse, rape, and murder. They are not to provoke the people, so that the people then become enemy combatants, whereby they could confiscate everything from the people. They create an argument. It was illegal in the first place for them to start with. They provoked the incident, not us. Executive Order 100 of the Leader Code, the military was handed the trust. The trusteeship went to the military. Okay, we are involved in a trust. I started before speaking about our name, all capitalized letter name. What could that possibly mean? Third grade English, the teacher said, don't ever write your name all in capitals, upper and lowercase. That's correct syntax language, the English language. Upper and lowercase. If it's all capitals, that means it's a corporation. What does that mean? A corporation? I'm not a corporation, am I? I didn't create a corporation. The Secretary of State doesn't have any filings by me that I wanted to start a corporation. How did this happen? Well, you're going to hear in a couple minutes how this came to be by the government, what they did. Okay, thank you. After the Leader Code, the Reconstruction Act of 1867, it was passed in order to take the public officials out of the state and put them under federal jurisdiction, in order for the civilians to maintain standing and not to deplete the country. Under military control, military law, the flag in the courtroom is proof of the military side of this. And that came in 1953, on or about. Under the bankruptcy, under the military control, the 14th Amendment had to come in to it as well. They sidestepped the 13th Amendment. Do you remember what the 13th Amendment is about, what Rob was talking about? That under the original 13th Amendment, there can be no titles of nobility to hold any public office, which would be lawyers, cannot be in judgeships, they cannot be in the Congress, they cannot be in the Senate, they can't be president. We have no lawyers whatsoever to make laws or anything. Because a lawyer, having an oath and being in the bar, which is foreign to us, they would be serving themselves, not serving the people. That's why the forefathers put the 13th Amendment into the Bill of Rights, so that we would be protected from that type of crime. They sidestepped the 13th. They already had lawyers in office, though, and what they did make was to make the public officials under the 14th Amendment. The 14th Amendment now applies to them. It made everybody in the government a 14th Amendment citizen. Okay? They could not leave them in a position of the beneficiary, because under the Reconstruction Act, they had to make every public office swear an allegiance to the District of Columbia. And it took them, made them take on the foreign status. The 14th Amendment in 1868 guaranteed that they would stay there on the federal side. They are the 14th Amendment citizens, not you and I. Through our history and the Patriot movement, they tried very hard to convince us that the 14th Amendment citizens were us. Reasons being was so that you and I would never understand what they were doing to us. And they could go after the trust. What trust? The 14th Amendment citizens are the trustees and cannot go after the other side of this trust, because they are doing this because we didn't know any better. We believed everyone telling us that we're the 14th Amendment citizen, a federal citizen. Guess what? No, we're not. We are American nationals, citizens that are sovereign, citizens of the United States of America, not United States citizens. We are sovereigns. Under the Reconstruction Act, the state had to relinquish its sovereignty under the Reconstruction Act. They didn't have a choice. They had to take on the federal mantle. The public offices had to do this. It doesn't matter if mom and dad filed our birth certificates or not. Okay? The trust was created by our birth certificates when we were born. Mom and dad didn't file the trust. The government did. Why would they do that? Well, in the bankruptcy of 1933, they realized, the government, that they could not get the trust. In order for them to get into the trust, they had to create a bankruptcy issue. And this is where we go from the statutory side to the bankruptcy side. This is why in 1938, statutory laws don't apply to anything. Licensing came in with registrations. We have to license everything because there's no more gold or silver, no monetary value. And the only thing left is credit. The credit of the nation. In the McFadden speech in 1933, page 83 of the Congressional Records, the money would be backed by 100% of the credit of the people. It would represent a mortgage on everyone's home and on the property of the people. It would represent an illusion, mortgage on everybody's home and property. It would allow them to borrow, to securitize, allow them to monetize it. It was not giving them the authority to confiscate it by creating an incident between them and us so that they could come under the Confiscation Act of 1861 and confiscate the property because we had become belligerent. We were not belligerent, they were. Okay, we're non-combatant, peaceful inhabitants. This birth certificate was created in order for the country to borrow money against, because they had no means to borrow under the bankruptcy. They took away our gold and silver, and by them taking away our gold and silver, part of the Reconstruction Act stated that they were to pay all of our bills.